Real life. Good afternoon, everyone. Myself, Nasma Abidi, welcomes you all to the ninth technical session of the ongoing maiden venture of the FDP organized by the Faculty of Law in Tata University. The International Faculty Development on Changing Paradigms of the Human Rights in Globalized World hypothesis, the contemplative and the serious issues of the human rights and changing dimensions of the law in the globalized world. The topic of the present discussion is protecting the human rights of the stateless person and international perspective. Nationality and citizenships are the fundamental element of human security because they provide people with a sense of belonging and identity. They also provide a legal basis for the exercise of many human rights. Today, millions of people around the world face serious difficulties owing to statelessness and nationality issues. Somewhere in the world, every 10 minutes, a child is born stateless. Out of 70 million displaced people, more than 24 millions are refugees, 41 millions are internally displaced persons, and more than 3.5 million people are asylum seekers. So, in order to elucidate, elaborate, enlighten, and acquaint us with this human rights issue, we have invited Dr. Namita Vashisht Ma'am, Assistant Professor, Faculty of Law, University of Delhi. Ma'am has an exquisite teaching and research experience in areas like international law, comparative law, wage law, criminal law, and human rights law approach to international law. Ma'am has been a stalwart member of the Faculty of Law, University of Delhi for the past 12 years and has worked as the convener, Debate Discussion Society, co-convener, placement assistant counsel, convener, IQAC, NAC, to name a few in some roles several times over. With more than 15 publications, MAM has also supervised various dissertation projects, research papers in the areas of labor law, media law, constitutional law in her academic competency. Supplementary to all the above accolades, MAM has also been a part of the British Institute of International and Comparative Law, United Kingdom since 2021. Bringing up prayer, I must say that the works and the accolades which ma'am has earned throughout her life in such a short span are so numerous that it takes long time to bring it to short in the allotted time. So without any further delay, I consider my privilege once again to welcome you, ma'am. Kindly enlighten us with the words of wisdom. Thank you, ma'am. Over to you, ma'am.
Thank you. Thank you, Najma, for that wonderful introduction. And
Thank you, ma'am.
so we'll just quickly jump on to our topic for discussion today. And the topic says that it is protection of human rights of the stateless persons and international perspective. Now, when we look at this whole the topic itself, the international perspective, it is very huge. Huge in the sense that a person becomes stateless owing to many circumstances. There are many provisions in different human rights instruments. There are specific convention where such a person is protected. But before we go ahead with that discussion of what their rights are, we actually have to have an understanding of what a stateless person is. So let me share a few slides with you. I hope I'll be able to share that. Just a moment. Is it visible? I hope it is visible.
Yes, ma'am, it is visible.
All right, all right. Thank you so much. Okay.
Ma'am,
So when we
kindly,
look at this,
excuse me, ma'am, kindly just put it
yes.
on slideshow so that it will cover the entire screen.
Okay. Yes, yes, I will do that. And I will also switch off my camera because there is a lag when I'm speaking. I can feel that lag here. जब मैं बात कर रही हूँ तो वो रुक रहा है. Just a moment. I will do that
Okay,
for
ma'am.
you. All right. To begin with, we have to have this understanding of who is a stateless person. Now, a stateless person, if you look at the definition, which is given in the 1954 Convention relating to status of stateless person. Now, this convention was drafted after World War II, as one can see the date. What we have to have an understanding from that is that after World War, lots of people were displaced. Now, at that point of time, over 1.5 million. So, this convention, coupled with the Convention on Refuge Law, was specifically made to make sure that the people who have been displaced specifically by war, because the war rendered many people homeless. So, to protect them, this convention was drafted, and a very strict kind of a definition was given for a person who is stateless. So, a person who is not considered as a national by any state under the operation of its law. Now, you can see on the slide that I have highlighted some parts in the, that colored part, the considered, national, and operation of its law. Now, the importance of these words is that if you look at the word considered, it is of subjective importance. Who is considered stateless, who is not considered stateless, that is very much dependent upon the law that is operative in a particular country. So, all the times we will have to refer to the domestic or the municipal laws of a country. As students of international law, all of us know that every state, being a sovereign, has a will, has a value. That is more of a positive law approach. And that will and value has to be accepted and respected. So, when we look at this concept of respecting the municipal law, the domestic law, this definition, which is of quite a very straightforward nature, that somebody who is not a national, not considered as a national. Now, look at this consider here. Once again, I will emphasize that a lot of subjectivity attached to this word considered, because that depends upon the domestic law of a particular country. So, this definition has been many a times put into a controversy, is understood with that question mark, that why just this definition, because people who are not only the legal who are not having that legal relationship with the state, only they are the ones who can who can be called as
Ma'am, the
stateless. What
slideshow has
about
not
other
yet started. Sorry to disturb.
I can see that. I can see that on screen. Just a moment.
No,
I will
ma'am.
just
The slideshow has not yet started, ma'am.
once again.
We are sorry for the issues in between. We will resume.
Is it visible now?
No, not yet, ma'am.
But from here, I can see that it is. I can it is
Yes,
asking me
ma'am.
to
Now it
stop
is visible.
sharing.
Now it is visible.
Okay, okay, okay. I think it's clear enough if I don't have to start the slideshow. Just tell me if the slideshow has started. Can you now see the
Yes,
slide?
ma'am. Yes, ma'am. We can see the slide now.
Now it is there? Okay,
Yes,
okay,
ma'am. Now
wonderful.
we can see it.
Okay, okay. So, all right, this is great. All right. So I was talking about this first slide here, that where to find out a person who is a stateless person or not, we will have to resort to the definition under the convention. Now, at the outset, I would like to just say that India has not acceded to this convention. So, as a country, we are not part of this particular convention and the second convention on reduction of statelessness. All right. Anyway, we have to have an understanding of what this is all about. So, a person who is not considered a national by any state is definitely subjected to the national laws of a particular country. And then there is subjectivity, because that depends on the country which will consider a person, depending upon its laws, depending upon, all of us know when administrative the executive works, then it can change policy from time to time. So we can have different policies at different points of time. So this consideration is a subjective issue. So, what happened looking at this definition, and as this convention advanced from 54 to later years, people realize that this definition is nothing but only in connection with nationality, because nationality is a legal bond between an individual and a state. And some countries, we also use this term citizenship. So nationality is akin to citizenship. And if somebody is lacking that nationality, it means that he cannot enjoy the rights that are provided for nationals. And that often leaves him in that marginalized and vulnerable section of the society. And also, we have to understand that if we do not possess rights, we do not become subject of law. What is a subject? Subject is somebody who's possessing rights and who's possessing certain duties, and also has the capacity to bring claims. तो एक समझने वाली बात है, जब rights and duties ही नहीं है और capacity to bring claim ही नहीं है, we will never be able to talk about rights of these persons. So there is absolute subjugation of these persons who fall in the category of a stateless person. So I was telling you about this de jure and de facto statelessness. Now, 1954 convention was also an extension of a 1930 convention. जैसे वर्ल्ड वॉर टू के बाद बहुत सारे लोग जो है स्टेटलेस हो गए, डिस्प्लेस हो गए, सो वी फॉर्म दिस पर्टिकुलर कन्वेंशन. आफ्टर वर्ल्ड वॉर वन ऑल्सो, when League of Nations were formed, League of Nations, one of the Treaty of League of Nations, the Hague Convention on Nationality in 1930, that also provided two protocols, on one protocol and one special protocol concerning statelessness, that was passed in April 1930. Now, all these considered a stateless person only in terms of nationality, only in terms of nationality. And that eventually prompted several legal scholars to believe that the concept of statelessness should encompass more than just this de jure. As you can see on the screen, de jure here, only legal statelessness. So there should be something more than this legal statelessness, because these legal scholars believed that 1954 convention is too narrow and it was limiting. And to be sure, it was also pointed out that this problem with this definition is that it excludes all those people who might have a nationality technically, but they are not able to obtain, by virtue of not able to prove their nationality with a particular country. Perhaps they have lost their papers, perhaps they have not been given access to prove their nationality. So in all these cases, even those persons can become stateless. So they introduced this term that statelessness should not only be de jure, it should also have a de facto statelessness. But over a period of time, the drafters of the convention, they had given one of the recommendations. Now, this recommendation was that they did not specifically distinguish between de jure and de facto statelessness. उन्होंने इसको अलग अलग नहीं किया, but they understood it in this sense that those who have not received nationality automatically, and all the other de facto stateless persons, those who cannot establish their nationality, they were recognized in the 1954 convention, because the final act of the convention, it addresses the issue of these stateless persons with a non-binding recommendation. Non-binding, the states are not bound to follow a particular recommendation. I think many of us know here that UDHR, Universal Declaration of Human Rights, that is also a non-binding human rights instrument. It is not binding on a particular country. So similarly, a non-binding recommendation as given in the 1954 convention, that says that each contracting party, the moment it recognizes for valid reasons for which a person has renounced the protection of the state for which he is a national, it should consider sympathetically. Once again, the convention has left the status of these people who are stateless, the de facto stateless people, they have been left at the subjectivity of a particular country. So it's not that they have not recognized that there can be some people जो कि national तो है लेकिन nationality prove नहीं कर पा रहे हैं, लेकिन उन लोगों को cover करने के लिए they have only given a non-binding recommendation. So these people who are stateless, who are also referred to as legal ghosts in international community, they have been having a lot of problems since the very establishment of the first convention. If you look at the modern international law which comes into picture, the later part which comes into picture after forming of the United Nations, they have been having a lot of problem pertaining to their rights. Now, before I go ahead with the rest of the discussion, these are certain terms that I would like to discuss. These terms are sometimes used interchangeably, but they are different. When we use the word stateless, we also tend to use the term refugee. Sometimes we use the term refugee and then we replace it with the word asylum seeker. Then there are people who are undocumented persons. These people, they do not have the documents or they have been unable to produce the documents. So we have to know that what these terms are. And then there is a last category that I've mentioned on the slide, and that is migrants. Sometimes illegal migrants or migrants who cross the borders, they are also referred to as refugees. Obviously these terms may overlap sometimes. A person who's a stateless can become a refugee. A person who is a refugee, it may so happen that he himself later on becomes a stateless person, but these terms are different. Now when we look at the word refugee, there is a convention on refuge law of 1951. Now that convention specifically defines a refugee as a person who, owing to a well founded fear of being persecuted for reason of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable, owing to that fear, that he faces, owing to his religion or race or nationality, owing to that fear, he is unable or is unwilling to go back to his own country. Now, refugees are those people who have actually left the territory to which they actually belonged. So they have moved to new
When
territories in
slides are
terms of.
not yet changing,
I've
we are
moved
on the
on to the next
same.
slide. There is some
When we are on the
problem with
same,
the.
we are on the same side of the statelessness. That is the legal rules. Now it has. Now it has.
Now it has. So let us put it on this mode only. Okay, let's stop the slideshow. I think there is some issue with the network thing or something. Is it clear now? Can you see there?
Yes, ma'am. Now we can see the different but confusing similar terms.
Yes, 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 yes. So when we look at refugee, this is a term जो हम कई बार confuse करते हैं stateless लोगों के साथ. Now it's not that stateless people cannot become refugees, but at least as students of law, all of us should have that understanding that refugee and stateless persons are technically different because they have been differently defined. And as I was telling you, that stateless person is specifically defined in terms of nationality, but refugee is that person who leaves the territory owing to the fear of persecution because of his religion, because of his race, because of the political opinion that he has, or because of nationality. So, again, or because of nationality. So, there can be an overlap somewhere that a refugee can also eventually become a stateless person, or vice versa. And this definition of refugee, it does not cover those individuals who leave their country because of war. Now look at this. When issues happened in Syria, it was a very difficult thing to put them in the status of refugees, because owing to war, that aspect is missing from the definition of the Convention of 1951. So that will explain that how even the conventions, when they are drafted, sometimes the ambiguity in them or the soft law approaches, they do not solve issues of human rights of all the marginalized group of the world. Now the second one here, the asylum seeker. Asylum seeker, as the word suggests, seeker, somebody who's seeking that international protection. The moment you seek that international protection and you are given, then you may be called a refugee owing to certain circumstances. But till the time you are still seeking that refuge, आप सिर्फ अभी मांग रहे हो refuge कि भाई मुझे जो है डर है या मेरी जान को खतरा है या political ideas जो है मेरे मैच नहीं करते, so XYZ जो भी reason हो, if you're asking for a political asylum or any other asylum, till the time you are given that status, active protection by the state. When we talk of asylum, we always look to the term that there is active protection by the state from which the asylum is being sought. So, agar वो asylum seek जब तक आप कर रहे हो, then you are just an asylum seeker. Now, this again is not to be mixed with a stateless person. We do use these terms, and that's why I chose that we'll have a quick discussion on all these. And then there is the last category here, the migrants. Now migrants or undocumented persons. Now migrants leave their country voluntarily because they feel that they do not have that kind of a prospect in terms of earning. They want to earn money, take care of their family, move ahead in life, and if they fail to find those opportunities in the parent country, they will leave and cross borders to earn money. They do not have the intention to leave their country permanently. They want to come back, obviously. So as long as they want to come back and they're not leaving countries owing to any other reason that is mentioned in the refuge convention, till that time they will just be migrants. And then there are undocumented persons, because identity of a person, as far as the documents are concerned, these documents, they serve as an instrument to prove a person's nationality. And if you're unable to prove your nationality, it will eventually not just make you stateless. It might, it not necessarily, but it might make you stateless. And without those documents, you will not be able to enjoy the rights which other citizens, because if you're not able to prove your nationality, you're no longer a citizen, you're no longer a national. And all of us know that even in our constitution, the fundamental rights, they are also divided in such sense that some are available just to the citizens of the country and some are available to the persons who are residing within the territory of India. So as long as we are not nationals of a country, we will be able to enjoy all kinds of rights that are provided to a national. So identification is also a big issue when we look at statelessness. But at the same time, undocumented person is not necessarily a person who is stateless. Now, moving further, now let us see that can a stateless person also be a refugee? Because in the previous slide, we were talking of that who is a refugee, who is a asylum seeker, and there can be an overlap. So the question that arises is, can a stateless person also be a refugee? And the answer is yes, because the recommendation that I was talking about earlier, the 1954 convention, it has presumed that all persons without an effective nationality, they all are de facto stateless persons. And as long as they are de facto stateless persons, they are to be considered refugees. You know, this is a principle of customary international law. The Refugee Convention says specifically that even if the parties, the states have not acceded to the convention, this remains a principle of customary international law. And just because a state is not a party to the convention, that doesn't mean that people who have who fall into this category where they have no nationality, they can be called as no refugees. So it is automatically presumed that all these people without nationality should be taken to be as refugees for the purpose of the convention. So the drafters, they, since they presumed that all these people are going to be refugees, they have given this kind of a status to the refugees under the convention, because they know that there is a well founded fear of persecution. As long as it is there, then they can always be called as the refugees under the convention. Now, what are the reasons for statelessness? क्यों हो जाता है कोई person stateless? Stateless is, or we are all are born in some country or some place or the other. Now, I want to introduce here Article 15 of Universal Declaration of Human Rights. Now, that gives us as the fundamental human right that all of us have a right to nationality. But at the same time, there can be reasons why a particular person is no longer is no longer a national of a particular country. Okay. Now, when we look at the first one, conflict of nationality laws, just soli and just sanguinis. Just solely is that it depends upon the place of birth whether you can be called as a national or not. Now, we have different systems, law systems over the world. We have the common law system, we have the civil law system, and then these systems behave differently in terms of nationality. So it depends whether they are recognizing the just solely concept or they are recognizing the just sanguinis concept, or like United States of America, they are recognizing both equally, that a person who is born in America automatically becomes an American citizen, or a person who is born to the American parent becomes automatically becomes an American citizen. So depending upon the state law, once again, the state law is very, very important here. They do not want to, none of the provision of these convention, they interfere with the domestic system or the municipal system of a particular country. Even though we realize that this is an issue which is growing day by day, the United Nations did resolve itself into eradicating statelessness by the year 2024. How far is 2024? And still, every day we see that the number of stateless person is increasing day by day. It's not lessening anywhere, and new numbers keep on getting add up. So when we look at this conflict of nationality law, that is a big huge reason why people are rendered stateless. So one example that I'd like to give you is, for example, according to the Kuwaiti nationality law, it does not provide any mean for any child of two stateless parents to obtain nationality. So if there is a child who has been born in Kuwait and he belongs to persons who both of them, mother, father, they are stateless, he cannot take nationality. Okay. So what is happening? That he is born to stateless parents, he himself remains a stateless person. And that you can relate to the last point here, inheritance of statelessness. So here you will see that बच्चे जो हैं, और बच्चे बहुत ज़्यादा number है, out of almost 15 million people, 4.5, it's nearing 5 million, they are children who are stateless. So one can imagine the state of these stateless persons all over the world. Not to just talk about their human rights, but what would they be facing. तो ये जो conflict है just solely का. Another example, now I was talking about USA. So I'll give another example here, that if a person, a male citizen, because many countries, these just solely and just sanguinis, yes, I also want to tell here, and I'm just writing here, that it also depends that whether they are giving the nationality based on paternal or maternal aspects. So most of the countries, they follow the paternal aspect or the paternal side for the purposes of nationality. Now imagine a state that there is a male citizen of USA, and let's say he moves to Belgium. Now, in Belgium, he marries a Belgian woman, and there is a son. He fathers a son. According to the principle of just sanguines, the son would automatically have citizenship of US because he's born to an American father. And if the son was born prior to 1984, the son would not receive Belgian citizenship because prior to 1984, Belgium just sanguines did not allow nationality based on parental descent only. So that would affect with his Belgian status. And if this son, the son that has been born in Belgium to the American father and Belgian mother, if that son marries a Belgian woman and he has never visited United States, then his children, those who are born before 1984, they would be stateless. Why? Because parental descent say he will not get, those children will never get citizenship of Belgium, and they will also not get citizenship of USA, because this son, the person who acquires citizenship by birth citizenship of America by birth and never sets foot in the territory, वो कभी American territory में गया ही नहीं है, that person's children will not have automatic citizenship. So, we sometimes have these issues based upon the nationality laws. And, over a period of time, Convention Against Racial Discrimination says that come se come jo just sanguines hai, this whole concept of nationality, this should be done away with. Place of birth should receive importance. Place of domicile, place of residence should receive importance, because this nationality principle is eventually leading. That's also one of my analysis of this whole discussion, that it leads to statelessness. बहुत सारे लोग सिर्फ इसी वजह से stateless हो रहे हैं क्योंकि उनके पेरेंट्स का जो नेशनैलिटी का स्टेटस है वो चेंज हो रहा है over a period of time, and that can change due to other factors. Now, another important point, the reason is discrimination, including against women. Now, we know our own Indian society and the manner in which the society function, that woman, she acquires, she becomes the custody. If there's a woman, she's in the custody of the husband. The moment there is marriage, her status changes. Now, that is also applicable to many, many places all over the world. Rather, there are almost 27 countries which do not recognize the nationality of married women individually. Okay, they do not have any rule or regulation to provide nationality to married women on their own. It is completely based upon the nationality of the husband. So this discrimination, particularly against women, this is also referred to as the dependent nationality rule. Because of this, lots of women, they suffer statelessness. Like, for example, if a woman from a state, she is deprived of her any woman of her state, the moment she marries across borders, she is deprived of her nationality on marriage, just because it is written that if she weds a man from an outside state, then as long as that man is enjoying nationality, she will have nationality. If that man becomes stateless, she also automatically becomes stateless. Not because she was never a citizen of somewhere, but just because her husband has become stateless. So you see, statelessness एक बहुत ही complicated issue hai. It is not just about people running from one place to another. There are many issues which render people stateless. And so one can imagine in cases of war where a lot of men specifically die, their women are left stateless, their children become stateless. So this is the issue that we face all across the globe, particularly relating to women and children as far as statelessness is concerned. Then there is an issue of state succession. A state succession is whenever a state is dissolved, or it is succeeded, or it is broken up. Again, the war-like situation, or where the territory is transferred from one country to another. So that transfer of territory also results in the nationality, the dissolution of the nationality, or the breaking up of the nationality. So that is also an important factor which results in statelessness of people. Then the next one, the administrative barriers. Okay, now these administrative barriers and lack of documentation. Recently, in our own country, we have been having a lot of debate as to how to prove nationality. Now, not going into that political aspect, but this very thing that you have to prove something, that also many a times results in statelessness. So you can imagine a situation that a family is living for 12 years, 10 years, or let's say 20 years or more than that. And that family, while residing, has never acquired any document, okay, and never felt like acquiring any document, or have lost any kind of documentation. What would happen to them? This is a great barrier in those cases where people have fled their places, moved to new territories, have started residing there, and owing to policy changes, now they fear statelessness. So ऐसा नहीं है कि जब the moment they enter they become stateless. Sometimes it is taken that they have those documents where they will be able to prove their nationality. But at the same time, administrative barriers, they are also a great reason for causing statelessness. In fact, many people who have researched on statelessness in Southeast Asia, they have given this as a major reason. If you can look to this particular slide here, you know, weak civil and registration system. Now, see this one. This is a weak civil registration system that also causes, specifically in Southeast Asia. This is a reason why a lot of people have been rendered stateless. Okay, so the last part here, inheritance of statelessness. This I was telling you that how children inherit statelessness. So the moment children, they are born abroad to refugee parents, they are at statelessness, in the risk for statelessness. For example, due to, let's say, there's a conflict of nationality. Okay, nationality of laws between the host country and the country of origin. So the host country is जहाँ पर वो लोग रह रहे हैं इस वक्त जब वो क्रॉस करके आ गए बॉर्डर. So the host country and the country of origin. And अगर उनके बीच में कोई झगड़ा चल रहा है, there is an issue pertaining to their nationality, then nobody knows the fate of these children. Okay, so they are in a way inheriting that statelessness. So these children, they will become stateless when parents cannot fulfill the conditions. So again, I was talking about this administrative barriers. So if the parents are unable to prove that state their nationality, that the children of that family, the children to that particular parents, those children will be devoid of their nationality as well. So there is an inheritance of statelessness also in many cases. So अगर आपके पास documents नहीं है, शादी के proof नहीं है, and sometimes, I believe that even we as individuals residing in a country, we do take things casually. So when it comes to paperwork and documentation, specifically for those who have fled their parent country owing to fear of persecution, they really want to, find that ground in the host country where they want to make documents, make sure that they are they are people of a particular country, because they have seen those violations, those extreme victimization, extreme abuse of human rights in their parent country. So as far as the reasons are concerned, and why do we need to look at the reasons? The reasons are very important because they help us to understand where we can check the problem. Where we can check the problem. Do we always look into the issue that a person has become stateless? Now, what are the rights that a person enjoys? Or we have to check the problem that why a person should become stateless in the first place. Okay, so I'll come to that part in the end of the discussion. Now, this Southeast Asia, another reason, other reasons that can be there for the statelessness. One attributes, particularly the colonial countries. वहाँ पर एक बहुत बड़ा problem रहा, because हम सभी इस चीज को accept करते हैं, मानते हैं that colonization was extreme victimization, extreme abuse. All of us, all the colonized countries face those abuse, displacement of people, exploitation of resources, economies were destroyed, whatever were there at any point of time. So this long shadow of colonial rule, as it is written, so that continued. People could not recover even after decolonization. So that resulted in large number of people displaced. Okay, there are people who live in the waters of Thailand in boats. They are migrant people, who आ रहे हैं बेचारे वहाँ refuge status में, who they cannot put their, take the risk of entering the land, because they know that they will be put to those refuge camps. They do not know what to do. And many countries, if I share this particular slide with you here, look at this data. Is it visible to you? The end of 2019 in millions. All these countries here, Bangladesh, Myanmar, Thailand, Syria, Malaysia, these are those top 10 countries with largest number of stateless population. Apart from Latvia, no other country is a member or a party to the Convention of 1954. So one can imagine what is happening in these countries, where so many stateless people are there. They have not been a party to the 1954 convention. However, as a student of international law for several years, I have also observed that even if they would have become the party, no principle or no rule of international law can override the municipal law, the municipal condition. So the first time, when I was talking about the nationality rule in different countries, this conflict of nationality laws is a problem even for the member states. And anyway, all of us know that whenever there's a treaty or a convention, we sign it and we have the power, the liberty to sign it with reservations. And many countries have, signed this particular convention of 54 and 61 with lots and lots of reservations. So ऐसा नहीं है कि पूरा ही उसको एक्सीड कर लिया है. But yes, many of them have come together to end this problem, this vicious circle. It's a kind of vicious circle. If there is displacement, the moment there is displacement, people are outside their territory. They are outside their territory, they become stateless. Once they become stateless, then they are unable to go back to their territory, and they are unable to enjoy rights in the territory where they are residing. So this further accentuates, increases the problem of statelessness. So it's a vicious circle. एक पूरा एक सर्कल ऐसा है जिसको ब्रेक करना मतलब ऐसा नहीं लगता कि आप उसको एकदम से ब्रेक कर पाओगे. Though there is an ambitious project on behalf of UNHCR where they say that we would like to end statelessness by 2024. Obviously, COVID has put all of us, in the bag here. And then historical or present mobile lifestyles, identifying affected individuals and group. Now, this is very an important thing. Just imagine somebody who's a stateless residing in some small part of the country. The moment he's subjected to whether you're a national or not, how much fear he will have to even say that I'm not a national of the country, fearing what would happen to him, fearing what would happen to the family. So identification is a problem, not just because there is lack of political will, but also because people do not want to come out freely and say that we are stateless, because they fear that they will be subjected to some XYZ law, and then either they will be deported or they will be sent back to the countries where they're already facing issues of persecution. So this is a complex issue again, that where we have to identify such people. Before we give any relief to anyone, we need to know who is that person who needs that relief. That is also a problem internationally. It is being faced by many countries. Different groups, they have come together where they're trying to collate the data. In fact, the June 2020 report, it itself says of United Nations in that institute on internationally displaced persons, that also says that whatever data we are providing, that data in itself is subject to variations, because they know that all the people are not coming out, and they are not able to reach all people who are stateless. Now, the key conventions, because we've talked about how a person becomes stateless, what exactly is statelessness, there are certain key conventions. The first one, as you can see, is Convention relating to status of stateless persons. Now, this 1954 convention that I've been referring to since the beginning, this convention is the first convention in the present day time which is applicable on stateless persons. And then there is the second convention, which was in addition to the 54 convention, reduction of statelessness. Now, reduction of statelessness, how it is done, that we are going to discuss, that how the state parties they are obligated to reduce the statelessness. क्या क्या वो कर सकती हैं जिससे ये statelessness का जो नंबर है वो हम रिड्यूस कर पाए ओवर अ पीरियड ऑफ टाइम. वो कौन से एफर्ट्स हैं या कौन से एक्शंस, कौन से स्टेप्स उनको लेने हैं, कहाँ उनको एक्ट करना है, कहाँ उन्हें फॉरबिड करना है. तो वो सारे एक्ट्स एंड ऑब्लिगेशंस और ओमिशंस जो हैं वो हमारे पास रिडक्शन ऑफ स्टेटलेसनेस convention 1961 में already mentioned है. And this was the project that I was talking of, as you can see here, a very ambitious project of the United Nations High Commissions on Refugees. Now, UNHCR has started this convention. It was started in 2014. So if I put here that it was started in 2014, that you have to come with the reduction of these this statelessness. ये कैसे हम कम करें और कैसे हम इसको खत्म ही करें. So they are aiming that they will finish it off, which again all of us know is not a possible target, particularly what we have seen over a period of time. The pandemic has done to all of us. And apart from these two specific conventions, there are different international human rights instruments and nationality provisions of the state. They help in realizing the human rights of the stateless persons. Okay. Once again, the nationality provisions of the state, if you go and check the website of United Nations Treaty or the treaties, there you will see that all the states who have signed this convention, in absolute, the convention has been signed with by those countries which are very few, which have very little population, where nationals are very few in number. But those countries which are having a larger population, either they have not signed it or they have signed it with many reservations. United States of America and India has not signed it. So we know many countries, but these are those countries specifically when we talk of migration, rules, regulations, human rights. These two countries, we have not signed any of these convention. Okay, um, so here, if we look at the rights under the convention, now there is a very important phrase here, and colleagues, please see, friends, if you see this particular phrase, as favorable as possible. So you look at the framing of this convention. Wherever rights are mentioned, this whole convention is based on non discrimination. It says that all state parties will ensure that these stateless persons, they are not discriminated against the nationals of a particular country within the territory. तो वहां आपको discrimination तो नहीं करना है. उसके साथ साथ they are using the term that they should be given at least minimum same treatment. Okay, not less than what nationals enjoy. You will not treat them less than the nationals, but if possible, as favorable as possible. जितना आप उनके लिए एक्स्ट्रा कर सकते हो, आप वो कीजिए. Now, if I talk about one of the reservations of Germany, that was particularly related to the wage earning aspect, that we can give them employment, but in no circumstance we will give them opportunity more than the nationals. So if they have specifically included this reservation while signing the 1954 convention. So non-discrimination is a very important aspect, that it is a right that is being enjoyed by the stateless person in the territory, at least of those countries which have signed. When I say signed here, what I mean is ratified, acceded. Okay, not just the signatory country. So where they have ratified the convention, these countries, they have to provide minimum same treatment. आप कुछ भी कीजिए, national से कम आपको उसको treat नहीं करना है. Another important aspect is access to justice. This is something we all agree to, that if a person is being victimized, how to resolve it. We may have, n number of human rights instruments, but if that person is incapable to bring the claim, if nobody is raising a voice for him, what is the purpose of all these written documents, binding, non-binding, or treaty? So we know that until unless they are given express access to justice, which at least the 1954 convention does, it specifically provides that all these stateless persons within the territory of the member state, they should be given, allowed access to justice in terms of abuse of their rights. Now, coming to this lex domicile, this is what I was talking of, that जो हमारे पास कॉन्सेप्ट है जी सैंगिन्स का, कि आपने जो है प्लेस ऑफ जो नेशनैलिटी प्रिंसिपल है उसको डिस्कार्ड करके, what we have to do is look at these people, look at the rights of these people in light of the concept of lex domicile, that is place of their domicile, or at least place of their residence, or at least place of their residence. Because it may happen that a person is moving from country 1 to country 2, and now he has come to country 3. So for country 3, his last place of domicile at any point of time would be country 2. So either you follow lex domicile, or at least you follow the place of residence where they are currently residing, for the purpose of at least recognizing, or at least enumerating that, okay, a person has 1, 2, 3, 4, 5 rights. So until unless we do that, it will be very difficult to provide any kind of access to justice, even because then we'll not be able to find out which law is to be made applicable. हम में से जिन लोगों ने प्राइवेट इंटरनेशनल लॉ या कॉन्फ्लिक्ट ऑफ लॉज पढ़ा है, वो समझेंगे, उनको बेहतर समझ आ रहा होगा अभी कि हम ये कॉन्फ्लिक्ट की बात करते हैं, when it the issue comes before a particular court, हमें ये पता ही नहीं है हम कौन सा रूल या रेगुलेशन अप्लाई करेंगे. So this recognition, we have to have an understanding of कि कौन सा law apply होगा, whether we apply lex domicile or we apply the law of place of residence of such stateless person. Apart from that, there are many rights which are given to stateless person. One is that of education, religion, the parity that has to be maintained. आपने बराबरी के rights देने हैं, whether the national or the stateless person. Right to religion, right to education, rationing, wage earning, self-employment, very important. Nowadays, we realize that people have, if they get those basic means, they can at least go ahead with self-employment, sustain themselves, and even contribute to the economy of the world. When we do researches, when we read texts about migrant laborers are running the economies all across the world. One cannot just, undermine the value of these migrant laborers. And therefore, not just because they are humans, but because the countries, they get that kind of a boost in their economy, we need to have rules and regulations to protect the labor standards and the social security, take care of the social security of such migrants. So self-employment, they also enjoy the right to property, movable as well as immovable. So, and in all these clauses, it is given that the state party should do everything which is as favorable as possible, and not minimum, not less than what the nationals are enjoying. So that is an important aspect, all these rules and regulations. And if at all, the last point that I've included here, because there are many, many, I don't really did not want to bore you people with writing one, two, three, four here. But the last part is important, that what happens in case of an expulsion? Can you expel a person who is stateless? You've not made him, once there is naturally, make him a citizen of your country, national of your country by the process of naturalization, to alag baat hai, he is confirmed to your standard, he's your national. But when he is not, can you expel him? And the convention says that the only ground for expulsion is public order and security. And friends, you will agree with me, public order and security is again a subjective issue. We do not have those standards which can say that XYZ is an issue of public security. There can be ABC, which are still issues of public order or security. And this is also dynamic, it changes from time to time. So this decision that a person is a threat to public order or security, it again rests with the municipal government or the law. So here, it is dependent upon the government of a particular state, and therefore we say that it is the government that is deciding whether a person is threat to public order or security. So these are the rights under 1954 convention, and they can only be given to those persons who are residing in those states which are members of the convention. Then the next part is obligations under 1961 convention. As I told you, the 61 convention is about reduction in statelessness. If you see the slide here, it is about reduction in statelessness. कैसे कम करें, वो क्या करें हम? So the United Nations has given the different steps that can be taken, 10 pointers specifically, resolving the existing major situations of स्टेटलेसनेस. अब ये बहुत ही एक रिजॉल्विंग कैसे करेंगे हम, वो कुछ यहाँ पे एस्पेक्ट्स हैं, बट अगेन कंट्री टू कंट्री डिपेंडेंट है, आइडेंटिफिकेशन एक प्रॉब्लम है, नेशनल लॉज अपने आप में कभी कभार इम्पेडिमेंट बनते हैं कि हम उन लोगों को इंक्लूड कर पाएंगे या नहीं कर पाएंगे. सो दीज आर थिंग्स दैट can act as blockages for resolving the existing issue. And then ensure that no child is born stateless. Now, those of us who have read Universal Declaration on Human Rights of Human Rights, sorry, Article 25 there, and the Convention on CRC, and CRC, that is Convention on Rights of Child, it says that if at all there is a child, in no circumstance he should remain stateless. Child, somebody who's less than 18 years of age. तो ऐसे cases में अभी हम लोगों ने डिस्कस किया जहां पर if the parent has been rendered stateless due to XYZ reason, then that statelessness also comes upon the child. So even though we have these written accounts where the child should not be rendered stateless, no child is to be born stateless. Now, born stateless is again a target. How do we do it? We make sure that people who are stateless within the territory, they are naturalized, they are made nationals, and then their children will never have this issue of statelessness. But again, that is an ambitious aspect. Whether a country, even after providing rights, they are allowing them to become the nationals, that is dependent upon country to country. Then removing the gender discrimination from nationality laws. Again, coming back to private international law, the conflict of laws, where we see that a married woman is dependent upon the husband. So the law should be drafted in such manner that her nationality is not just to be decided based upon the husband. In case she loses the husband is no longer there, either he has died or she's divorced or she has been separated. So in all these cases, rules should be neutral in terms of nationality. Then preventing denial, loss, or deprivation of nationality on discriminatory grounds. Now, this is something, again, uh, Friends, when we look at discriminatory grounds, what is discriminatory? That depends. Sometimes we talk about as, there have been discussions recently based upon religion, based upon races, that we prefer a religion, we do not prefer a particular race, or we will prefer a particular nationality, or we will prefer a particular group and not the other. All these cases, discrimination, again, it is going to be a relative concept. Sometimes people argue that Article 14 in India, it talks about equality of laws and equal protection of laws. Yes, but what we fail to see here is that when any policy is made into a law itself, that becomes law of the land. And what we require is equal protection of law of there, equal protection not of international law. So, these are some conflicting areas when it comes to statelessness and the discriminatory grounds. Then we have preventing statelessness in case of state succession, that we've already talked about, that in case there's a state succession, and so we should at least accept all the people coming from new territory, or where there is cession of the territory, हमने एक territory दे दी है किसी को, at least the pacts, the agreement should accord the status of nationality to those persons. The last part here, in terms of 1961 convention, is granting protection to stateless migrants and facilitating their naturalization. Again, this is something that depends upon political will and economic status of a particular country, whether the country is ready to bear the economic burden of these people who are being added to the country. Because migrants, when they come, when they they get into a country in huge numbers, they are, as I said, adding to the economy, but at the same time they're also adding to the burden on a particular country in terms of resources. So whether we are really ready to do that or not, that depends on country to country approach. Ensuring birth registration for the prevention of statelessness, this again, coupled with administrative and political will, can facilitate reduction. In case we have weak administrations, we do not have people who are really willing to come forward, get themselves registered, or at least the authorities that are not facilitating the registration, this whole idea of reduction of statelessness, it goes down the drain. Now, the one that I've highlighted, issue nationality documentation to those with entitlement to it. If you look at it carefully, the word entitlement, who's going to decide that? Who will decide entitlement? The convention is silent about it. Who is entitled to? The convention doesn't talk about, okay, XYZ is entitled to. This entitlement again depends upon the municipal laws of the country. So my point here is that even if we have these, these international instruments, that okay, these are rights and this is how they need to be protected, we have to really go back, check the definition, check the manner in which they have written. Obviously we cannot, again, the whole concept of international law is all about self restraint and positive morality. We cannot just transgress the rights of another sovereign, not interfere with his working. But at the same time, if at all we are coming out with any kind of a written document in terms of covenant or convention, we have to make sure that we avoid ambiguity. Then only we can realize the actual goal or scope of that particular convention. And then accede to further statelessness conventions and improve the quantitative and qualitative data on stateless populations. Again, political will is very much needed to make sure that we have such data with us. Last but not the least, these are those different human rights agreements. The UDHR Article 15, where it says that when we are talking of nationality is something that every person has a right to nationality. Okay. And then International Covenant on Civil and Political Right, it says that every child has a right to acquire nationality. And ICCPR is a binding instrument. We have to submit reports periodically. So this is again a very important aspect, that a child less than 18 years of age has a right to acquire nationality. Obviously, there is a big threat if at all countries follow this strictly, give nationality to the child and renders the parents as stateless, there will be separation of the child altogether. And most of us have heard issues where we see that on Indian and the American Mexican border, we see that parents and children have been separated for a long period of time. Okay, so that is a dangerous situation altogether. And then we have Convention on Rights of Child, where Article 7 says that every child should be immediately registered after the birth. Okay, so that again requires a political will and also people coming forward, because they have a right to acquire nationality, and state parties, they are obligated under CRC to implement these rights whatever are given in CRC. Then Article 9, again, very important, as I was talking about Convention on Nationality of Married Women and elimination of all forms of discrimination. These two, they say that neither marriage to an alien nor change of nationality by the husband should affect the nationality of the woman. But we see that because most of the time, when it comes to marriage, they are governed by personal laws of respective religions, things change drastically. So even if we have provisions which say that they are binding and the nationality should not be affected, this does get affected and hampers the issue of reduction of statelessness. After that, we have Article 3 of Convention Against Torture. For that, which I want to take you to this very site, non-refoulement. This is a principle of jus cogens. People who know what jus cogens is, that these are peremptory norms of international law from which no deviation or derogation is allowed. So as long as, and again, when we talk of non-refoulement policy, this is basically a customary law as well. But colleagues, we know that this policy, it's which says that the refugees or the asylum seekers, they will not be forced to return to a country in which they are liable to be subjected to persecution. All of us know that even if it is jus cogens, no country can actually be, nannied. उनको हम जो है कि order नहीं कर सकते कि आपने ऐसा नहीं करना है. Because whenever there is a conflict of international law and municipal law, it is a municipal law that shall prevail. And even if we have extreme measures that can be taken at international level, one really would not, or at least refrain from interfering with the domestic issues. That is why, countries, when they do not want to be interfered with, they are most unlikely to take an issue from the domestic level to the international level, because they want to be very very possessive about it. नहीं नहीं, ये तो हमारा domestic matter है, ये international matter है ही नहीं. Because as long as it remains domestic matter, there's an absolute control of the nation country. So even if, and this is pertaining to Article 3 of United Nations Convention Against Torture. ऐसा नहीं है कि even if it's used cogens, it is not written specifically. It is specifically written where it is given that no state party shall expel, return, or extradite a person where there are substantial grounds for believing that he would be in danger or subjected to torture. So when we talk of these stateless persons who have left their countries owing to that fear of persecution based on XYZ, the reasons, religion or race or nationality, why would they be subjected to the same torture by sending them back? And even if that particular country is willing to receive, most of the time they're not willing to receive, okay, but even if they're willing to receive, if the person fears कि उसको लग रहा है कि उसको वो डर है, for fear of, he is unwilling to go back, we cannot force that person as far as the United Nations Convention Against Torture is concerned. And if at all he has to be sent back, if at all he has to be sent back, one will have to go deeper to find out the relevant considerations, which are consistent pattern of gross, flagrant, or mass violations. So as long as there are consistent patterns, okay, different countries adopt different manner. For example, United Kingdom, over a period of time उन्होंने accept कर लिया है कि medical जो है evidence किसी person का that he has been subjected to torture, that is sufficient to establish that he is going to be subjected to extreme torture once he is sent back to his own country. तो हमारे पास सब कंट्रीज के अलग अलग मैनर एंड मेथड्स हैं जहां पर उन्होंने एक्सेप्ट किया है वो तरीका जिससे दे विल कम टू दिस relevant considerations before sending a person back. So in final analysis, okay, uh, if you look at what exactly, the number of stateless persons, if you look at the number of stateless persons, as I was talking of, these countries, it's huge. It looks like a far off dream, but in practice, it is very much dependent upon the national laws of a country to ensure that their human rights are well taken care of. Thank you.
Thank you so much, ma'am. Uh, Thank you so much, ma'am, for the information that you imparted to us in relation to the human rights perspective pertaining to statelessness. And in order to keep this session going, I would like to put up some questions which have been put forth by the participants. And the first question states that is the 1954 convention only instrument that is relevant to the rights of the stateless persons?
uh, as I have already, as I was sharing the slides with you people, I will just once again refer to it. It is the only instrument which is specifically talking about the stateless persons. Okay. Now we have seen that there are other generally binding, non-binding rules and regulations which are given in other slide that I was sharing with you, other in human rights instruments. For example, the UDHR or the CRC. Now those are general provisions which are to be binding on states, but specifically dealing with stateless, जो कि definition से confirm करता है somebody who has lost the nationality. These are the two conventions, one of 1954 and the second of 1961.
Thank you, ma'am. Another
Okay.
question that has been put up and states that does the 1954 convention compels a state to grant stateless person entry or residence? Does the 1954 convention
Yes.
compel?
Now, see, it's a very interesting question and a very important question as well. Because when you look at 1954 convention, it nowhere tells you that under what circumstances you will have to accept such people. Okay, because 1954 convention is never read in seclusion. Whenever we have issues of statelessness, we always also refer to the Convention on Refugees. So 1951 कन्वेंशन, as I was telling you, कि वो ऐसा वक्त था वर्ल्ड वॉर के बाद हमने एक कन्वेंशन बनाया, and it was primarily all these conventions are about the conditions, the treatment of the people who are either refugees or stateless or both, but none of them actually tell us that in what conditions they should be allowed. But as I was talking about the last in the last slide, when I was talking about the principle, the use cogents of non-refoulement, that if at all a person has come on the border and he wants to enter because he fears for his life owing to XYZ reason or persecution, then he should not be sent back altogether. And that is also applicable to those people who are not members, because it's a customary principle of international law.
And another question that has been put up and
Yes.
states that are the states obliged to treat stateless persons equal to their own nationals?
Yes, yes. 1954 convention specifically talks about non-discrimination, and it says that minimum treatment should be equivalent to nationals. In fact, it adds to it that as favorable as possible, as
Yes,
favorable, so it can even exceed. And apart
yes,
from that, there is also an important provision that if at all the country wants to provide them more rights based upon other human rights instrument, these
yes,
stateless people will not be denied of it, just because they are confirming to 54 standards. So they will not say that okay 54 में हमारे पास ये rights है तो हम बस यही follow करेंगे. No, they can give them even more rights. So 54 is a ambitious convention. It's an ambitious convention in terms of rights of the stateless people.
stateless persons. Okay, thank you, ma'am. Thank you again so much, ma'am, for answering such questions and enlightening us with your words of wisdom. And
Thank
now
you
I would
so much,
like to
Rajni.
thank you. Now I'd like to invite Ms. Ramya Singh for addressing the room.
Thank you so much, Nazma ma'am, for inviting me. Good afternoon, one and all. As we come to the close of this session, I, Soumya Srivastav, Assistant Professor, Babu Banarsi Das University, Lucknow, on behalf of the entire Faculty of Law, Integral University, would like to express my pleasure to deliver the vote of thanks. In the beginning, I would like to thank the convener, Dr. Mirza Junaid Beg, and the coordinator, Ms. Shipra Mishra, for organizing such a wonderful event. With profound privilege, I would also record my sincere appreciation to Dr. Namita Vashisht ma'am, Assistant Professor, University of Delhi, for giving us time from her busy schedule and discussed with us the issues of a stateless person, highlighting international perspective, their rights, and international mechanism for dealing with the same. This type of event cannot happen overnight as it requires planning and hard work for making it successful. I want to thank each one of you for your commitment, for your dedication, for your time, and the extraordinary work that you all are doing in indeed difficult circumstances. So, thank you all. Last but not the least, I also want to thank all the participants joined virtually from universities and colleges across India as your participation has made this program a successful event. To conclude, let me once again reiterate my gratitude to all. Thank you everyone. Have a great day.
Thank you,
Thank you so much, ma'am,
Soumya. Thank you.
Thank you.
for the vote of thanks. Thank you, ma'am.
Thank you, Nashma.
Thank you, ma'am.